From October 24, 2013, the School of Public and International Affairs at North Carolina State University hosts Richard Hasen, senior editor of the New Republic and professor of law and political science at the University of California, Irvine, for his presentation entitled North Carolina's New Front in the Voting Wars.
Welcome to the 2013 mostly annual NC State School of Public, don't make faces at me, School of Public and International Affairs American Ideals Lecture Series. In this series, we like to bring in experts, often journalists, academics, people of great knowledge who can speak about contemporary issues of concern, for example, voting rights, voting laws, and do that in a way that can put it in a deeper, broader context of American values, American ideals, kind of understand really how these contemporary issues are shaped, how they got here, where we're going, etc. So, given the current context in North Carolina, the big changes in our voting laws, I was honestly super excited to be able to have Richard Hasen.
Hasen.
I was practicing all day. And I messed it up. Hasen, like Fasten. Sorry, I apologize. Darn it. When I finish, I'll try it again. So Richard Hasen, like Fasten, here today, who is, I think, safe to say, America's foremost expert on voting and election law. He is the Chancellor's Professor of Law and Political Science at the University of California, Irvine. I do have to say, I'm especially impressed that he managed in a course of 6 years to do a PhD in political science and a JD, his law degree, at the same time. And when it comes to election law, he again, is a foremost expert. He's edited the Election Law Journal. He runs the Election Law blog, which if you're interested in this topic, which hopefully you are, since you are here, would be great for you to bookmark and check out. And I think no further ado is required, and I will turn it over. Oh, and any questions you may have, we are going to have some Q&A at the end, so hold on to those questions and we'll get them.
Thanks very much. It's Stephen Groan, is that? Can you hear me all right with this mic? Yes? All right, great. Well, so I want to thank the university and especially Stephen for the opportunity to address you on these questions that are important about the functioning of democracy and the political process, not just in North Carolina, but in the nation. And I think a lot of people are looking at North Carolina now and trying to figure out what national lessons we can learn about the situation. I want to begin with a story which might sound familiar. Following election reforms in North Carolina, African-American voter turnout surges, setting records. The North Carolina legislature then changes hands, and the new party in power, which has few, if any, African-American supporters, passes new voter restrictions, making it very difficult for African-American voters to vote. Turnout plummets in the state, cratering among African-American voters. The story is true. The year was not 2012, when African-Americans helped put North Carolina in Barack Obama's column for the presidential election, but 1900. And the party doing the disenfranchising was not the Republican Party, but the Democratic Party. In his path-breaking book, The Shaping of Southern Politics, Professor J. Morgan Cowser tells the compelling story of African-American disenfranchisement at the beginning of the last century. North Carolina had what Cowser characterized as perhaps the most democratic political system in late 19th century South, with high turnout among adult males, with black men voting in very large numbers, and without the extensive ballot box stuffing and election fraud which was common in many southern states. Back then, of course, African-American voters supported the Republican Party, the party of Lincoln, which had strong black support in the state. But white support for the Republican Party was limited to the hill and mountain areas, as racist white voters would not vote for the so-called black party. Populists put up their own candidates and gained some support. And by the 1890s, Republicans and populists joined together, fused, and put up a fusion set of candidates, which captured the North Carolina legislature in 1894. Then, as now, North Carolina was a closely divided partisan state, and state laws changed as parties changed power. Along with adopting a more progressive legislative agenda, the fused Republican populists passed major election reforms, reversing earlier Democratic laws suppressing African-American turnout. Cowser called the new laws probably the fairest and most democratic in the South. Among the changes, election law judges from each party. In the past, the party in power would choose an incompetent person from the other side to look over things. More voting precincts, no more than 350 people to a precinct. The burden of proof on challengers challenging voters. And the creation of colored ballots and party emblems to help illiterate voters vote. And you can see a picture of what one of those ballots looked like. The reforms worked. Turnout hit a whopping 85.4% of eligible voters in 1896. Black turnout was the highest in any Southern election since 1876. Republicans got their first North Carolina governor since Reconstruction, and the fused Republican populist parties increased their majorities. An African-American, George H. White, was elected to Congress from North Carolina. But Congressman White would be the last African-American member from the South until 1972, and the last from North Carolina until 1992 with the election of Mel Watt and Eva Clayton. There was a backlash against African-American success. Democrats resorted to fraud and violence in 1898, and the Republican Party populist coalition got strained in disputes over racial policies. Democrats took the state legislature over, and their first order of business was to reverse the election reforms in order to ease the passage of a state constitutional amendment to disenfranchise African Americans. The News and Observer newspaper editorialized in favor of reversing the election reforms, stating that the legislature should, quote, make it impossible for any element of white voters to appeal to Negro voters upon any public question. The purpose of the reforms was to disenfranchise blacks and lower-class whites. The new election law changed election day from November to August. It required registrars anew to have discretion to exclude voters. Finally, it brought back the 8-box. And you can see a little picture here of the 8-box, whereby election officials would decide which of these boxes would count. And they'd be moved around throughout the day. So you could decide which ballot to put your ballot box in, but unless you put in the right ballot box, and it was whispered to as to which was the right ballot box, your vote would not count. With the new election law in place, the fight turned to a plebiscite over a disenfranchising constitutional amendment, a fight which got ugly. Former member of Congress and Wilmington Mayor Alfred Moore Waddell, who was once a racial moderate, told an election eve crowd, quote, "You're an Anglo-Saxon, you are armed and prepared, and you will do your duty. Go to the polls tomorrow, and if you find the Negro out voting, tell him to leave the polls, and if he refuses, kill him, shoot him down in his tracks." Thanks to fraud, intimidation, violence, and racial animus, the amendment passed. Afterwards, the overall voter turnout in North Carolina plummeted, and African-American turnout dried up completely. Eventually, the state Republican Party gave up on African Americans, now disenfranchised and unable to support the party, causing long harm. Now, the fight in 1900 was about race, and it was about partisan politics. You couldn't separate the two. Racial politics affected the composition of the political parties, and the parties engaged in racial politics, in part for partisan ends. The story Cowser tells is a story of race and party. The only way to fully understand it is to see the complexity and interaction between race and party. Fast forward to 2013 and the new fight in North Carolina over House Bill 589, which has gotten national attention. The law passed by the new Republican legislature over staunch Democratic objections includes a strict voter ID provision. The law also cuts a week off early voting, although it keeps the same number of early voting hours, bars local election boards from keeping the polls open on the final Saturday before the election after 1 p.m. It eliminates same-day voter registration. It opens up precincts to challengers who could gum up the works at polling places and dissuade voters from showing up in the first place. It bans paying voter registration circulators by the piece. It eliminates pre-registration for 16 and 17-year-olds in high schools. And it says that a voter who votes in the wrong precinct, maybe because of a poll worker's error, will have her whole ballot thrown out. Earlier law had allowed such ballots to count in races in which the voter was eligible to vote. Like the fights in 1900, today's fight over North Carolina's controversial law is about race. And it's also about party. In this way, it's nothing new. But thanks to the way the United States Supreme Court has conceived of the meaning of the United States Constitution, and how Congress has written the Voting Rights Act, we may be forced to choose race or party. The realignment of the parties in the South following the civil rights movement in the 1960s has created a reality where by 2000, most African American voters are Democrats, and most white conservative voters are Republicans. That wasn't the case before the Civil Rights Movement, when there were Southern Democrats who were conservative and Northern Democrats who were more liberal. That means that when the Voting Rights Act was passed, it wasn't seen as a law that helped the Democratic Party, quite the opposite. But today, many people view the Voting Rights Act as a law that favors Democrats. And of course, things were flipped in 1900, when the Republican Party was the party of the black voters and the Democratic Party of racist whites. When race and party coincide, it's much harder to separate racial and partisan intent and effect. Today, white voters in the South are overwhelmingly Republican, and in some of the southern states, less willing to vote for a black candidate than are white voters in the rest of the country. The Democratic Party supports a left-leaning platform that includes more social assistance to the poor and higher taxes. Republicans view such plans as aiding racial minorities. Given the overlap of considerations of race and considerations of party, when a Republican legislature like North Carolina's passes a law making it harder for some voters to vote, is that a law about race or party? As I'm going to explain, if we call this a law about party politics and view it through the lens of partisan competition, then the law is likely to stand, and the fight over it will be waged at the ballot box. If the courts call this a law about race and view it through the lens of the struggle over voting rights, then the law is likely to fall, and the fight will be settled primarily in the courts. This contrast was briefly on display in a brief filed in a case involving Texas and the Department of Justice. DOJ said that Texas in its redistricting was discriminating on the basis of race in violation of the Voting Rights Act. Texas's defense was that it was about partisan politics and not race, and therefore acceptable. DOJ's accusation of racial discrimination are baseless, the brief said. In 2011, both houses of the Texas legislature were controlled by large Republican majorities, and their redistricting decisions were designed to increase the Republican Party's electoral prospects at the expense of Democrats. It's perfectly constitutional for a Republican-controlled legislature to make partisan redistricting decisions, even if there are incidental effects on minority voters who support Democratic candidates. Note the incidental racial effects. Now let's put aside for the moment the curious fact that Texas, by admitting that it was deliberately passing its law to hurt Democrats, was doing so as a defense rather than it being an indictment of Texas's conduct. In most other countries, it wouldn't be okay to say, hey, we passed the law in order to hurt the other party. We're going to come back to that. But suppose that Texas is right, that this is a valid defense under the law. Discrimination on the basis of partisan affiliation is just fine. Then we're left with the courts having to make this distinction, race or party. And so I want to take a step back, ask how we got here. How is it that North Carolina passed what I see as the most restrictive set of voting laws passed anywhere in the country since the 1965 Voting Rights Act? And I want to look at this twice, once through the lens of party and the other through the lens of race. And I'm going to argue that the solution to these battles over what I've called the voting wars is going to have to come from the federal government, and it's specifically, given that we can't expect anything out of Congress these days, going to have to come from the federal courts. And I'm going to argue it's up to the courts to engage in a more rigorous review of arguably discriminatory laws that discriminate on the basis of party, and that states have to come up with real reasons and not conjecture for their laws. Doing so would help to restore the core American value of equality of suffrage, something which the Civil War and post-Civil War battles were fought over, the right of all eligible voters, but only eligible voters, to be able to cast a vote that will be fairly and accurately counted. So let me begin by situating North Carolina in the context of the national battle we've witnessed since 2000 over the rules for running our elections. Before I get into those details, I want to talk about the 2005 Egyptian election. I'm sure you remember it very well. Incumbent Hosni Mubarak was running in a race against Ayman Noor. You all remember the Noor campaign, Get More with Noor. So, according to Wikipedia, which is where I get most of my information, Hosni Mubarak polled 88.6% of the votes compared to the very scant 7.3% for the vote for Ayman Noor. He never should have come out for higher taxes. Now, we look at these numbers and we know they're not serious. In fact, in another election, Hosni Mubarak got 100% of the vote. Here was a headline just last week in the Washington Post. Oops, Azerbaijan released election results before voting had even started. Now, in fairness to Azerbaijan, after the election, when they released the totals, the president actually did even better than the pre-released votes. So he's done really well. It doesn't always work out so well when the people don't have faith that ballots are being accurately counted. So here's Tahrir Square in Cairo in 2011. Here's Moscow in 2011, when it was widely believed that Putin was padding his legislative majority through election fraud. And here's the United States in November 2011. At the top is a Tea Party rally. A woman's holding a sign that reads, "No Chicago-style politics in Texas. Voter ID works for me." At the bottom is a labor union rally in Philadelphia. Voter ID equals a poll tax. It's a problem if we start worrying about the fairness of our election process. All of this goes back to Florida. You may remember Katherine Harris, if you're old enough. She was the partisan election official who was in charge of the election process in Florida. Not only was she the chief election officer of the state, she was also the honorary co-chair of the Bush Election Committee. In no other country do we have, no other advanced democratic country, do we have chief election officers also serving as honorary chairs of a candidate's campaign. And let me be clear, Katherine Harris was no aberration. Throughout Florida, down to the local level, it was all partisan officials. Would it shock you to know that in democratically controlled counties, they were much more likely to use a standard to find votes for Gore than in Republican counties? The problem of Florida was also with technology. The famous butterfly ballot caused the famous Jews for Buchanan vote in Palm Beach County. Thousands of people who thought they were voting for Al Gore voted for Pat Buchanan. We had problems of partisanship, problems of localism, problems with technology. And the lessons we learned from Florida are the wrong ones, that it's okay to game the system for partisan advantage. And the parties have been doing it ever since. What's it led to? Well, one thing it's led to is much more litigation. So every election around September, I get a phone call from the press. We're going to have a big problem in the election in November? Say, well, I don't know. Why haven't things gotten any better? Well, because for 3.5 years you haven't been calling, because nobody pays attention to how we run our elections until it's just before Election Day and it's too late. So what is the one thing we see? More than doubling the amount of election litigation in the period before 2000 to the period after 2000. Election laws become part of a political strategy, and it affects voter confidence in the process. So the National Election Studies asked voters, do you think the election was run fairly or not? So in 1996, before any of this happened, we have a good baseline. About 10% of voters thought the way the process was run was very unfair. In 2000, it shoots way up. Look at 2004. That's what's interesting to me. John Kerry running against George Bush. After the election, 21.5% of Democrats thought the process was problematic, compared to only 3% of Republicans. Let's contrast that with what happened in Washington State in their gubernatorial election in 2004. First, the Republican was declared the winner. Then the Republican was declared the winner again after a recount. Then the Democrat was declared the winner after a court challenge. There, 68% of Republicans thought the way the election was run was very unfair, compared to only 27% of Democrats. The lesson is clear. If my guy won, the election was fair and square. If the other guy won, there must have been some fraud. There must have been some suppression. There must have been something wrong with the election. And this has had an effect on voter confidence. Look at these numbers on the basis of race. So in 2004, Pew asked, how confident are you that your votes will be accurately counted? 63% of whites and only 30% of blacks were very confident. 8% of whites compared to 29% of blacks were not at all or not too confident that their votes would be accurately counted. All right. I want to take this big issue about the fights over these rules and spend a little time talking about voter ID, which is the issue that gets, I'd say, the most attention here. Probably shouldn't be, but it is the issue that gets the most attention. And I want to start by telling you the story of Mario Gallegos. Mario Gallegos was a state senator in Texas, a Democrat. He was in Houston recovering from a liver transplant, but he had to be transported to the Capitol Rotunda in Austin to vote to filibuster the Republicans' voter ID law. So they'd put him on a hospital bed, they'd wheel him in, he'd vote, and then they'd wheel him back out. The fight was so bitter. Democrats for years, even though they were in the minority in the Texas legislature, used all kinds of procedural tricks to stop voter ID from passing in Texas. Gallegos said, It was a Karl Rove trick to suppress the vote. It's the last gasp to suppress the vote. In 2009, the Democrats' luck ran out. Rick Perry signed what was then the strictest voter ID law in the country. No student IDs, but concealed weapons permit is just fine. That's not a joke, that's true. And he said that the law was necessary to preserve the integrity of the election process. Well, Texas until this summer was covered by Section 5 of the Voting Rights Act, so it had to get permission from the federal government before it made any changes in their voting rules. Eric Holder said, I'm blocking the law. Voter fraud's not a problem. This is going to suppress the minority vote. A court agreed and blocked the Texas law. That was before the Voting Rights Act was struck down, or the part of the Voting Rights Act was struck down by the Supreme Court. With the end of this preclearance regime, which I'm going to talk about in a few minutes, we moved to a situation where Texas's law is being put into effect right now. Right now. And in fact, there's a big dispute now about women who are married and do not have their they don't have their husband's names on all of their documents, and whether or not those are going to count. I just linked to a story on my blog yesterday about a judge who had been voting for 52 years, and for the first time she had trouble voting at the polling place because her middle name on her driver's license was her maiden name, but her middle name on the forms that they had at the registrar's office was her actual middle name. And so, as we're going to see, a lot of the details of how voter ID is done make a big difference. But the fight was so bitter in Texas that the Republicans couldn't wait. They had to get this passed immediately. Right? Why so bitter? Where did this come from? So before 2000, talking about voter fraud, that was not a serious issue. But groups sprang up out of nowhere and started saying that voter fraud was a big problem. There was a group called the American Center for Voting Rights. It didn't exist until 2 days before a House hearing into problems of voter fraud. It sprang up out of nowhere, and then one day, 2 years later, after criticism by lots of people, it disappeared. Its website wiped out, its Wikipedia page cleansed, and the guy who was the head of this group, who's a partner at a major Washington law firm, has removed it from his resume. You'll find no reference. You'll see that he testified before the Carter-Baker Commission, but it won't say he testified for this group. This group pushed what I would consider a message with racial undertones about the problem of voter fraud. So here's what it said on their page. Talking about what was going on in Ohio, third-party organizations, especially ACT, Acorn, and the NAACP, engaged in a coordinated get-out-the-vote effort. A significant component of this effort appears to be registering individuals who would cast ballots for the candidates supported by these organizations. This voter registration effort was not limited to the registration of legal voters, but criminal investigations and news reports suggest that this voter registration effort also involved the registration of thousands of fictional voters, such as the now infamous Jive F. Turkey Sr., Dick Tracy, and Mary Poppins. Those individuals registering these fictional voters were reportedly paid not just money to do so, but at least in one instance in crack cocaine. The crack cocaine story is actually true. In my book, The Voting Wars, I went and tracked this down. We do have one case of this actually happening. American Center for Voting Rights said there was an epidemic of voter fraud. Now, at first it was a fringe idea, but by 2010 it was accepted Republican orthodoxy. So here's conservative commentator Michelle Malkin speaking just before the 2010 election. She said, denial is not just a river in Egypt, it's the Democrats' coping mechanism for midterm election voter fraud. Faced with multiple reports of early voting irregularities and election shenanigans across the country, left-wing groups are playing deaf, dumb, and blind. Voter fraud? What voter fraud? Now, if you remember the 2010 election, that was the Tea Party election. That's when Democrats took what President Obama called a shellacking. What did Michelle Malkin have to say about voter fraud after that election? Nothing. Voter fraud? What voter fraud? It's only voter fraud when Democrats win. And here's Dick Armey, the former majority leader. Armey claimed that 3% of ballots cast were fraudulent Democratic ballots. Quote, I'm tired of people being Republicans all of their lives and then changing parties when they die. Where was his support for the 3% figure? He made it up. So, in writing my book, The Voting Wars, I tried to find a single election where voter impersonation fraud made a difference. Now, let's talk about this, because all fraud's not the same. So, a voter ID prevents you from impersonating someone else. There's two ways we could do this. Carrie, is that where you live?
Yes.
So I walk into the Cary polling place and I say, I'm Stephen Green. And chances are the person behind the table says, no, you're not. My son plays soccer with Stephen Green's kid. But I'm going to guess he's out of town and the people don't know who he is. All right, so I'm going to do this. I'm going to do this on a large enough scale. I'm going to get all of you. We'll do this all together. And we're going to go out just now. I can't go with all of you to the polls. So I'm just going to trust you that you're going to go to the polls, say you're someone else, and you're going to vote the way I want, and I'll give you $20. Now, that's a really dumb way to steal an election. I'll tell you some smart ways in a few minutes. This is not the way to steal an election. So I was looking for a case. When have people tried to steal elections this way? Oh, the other way to do it is in Texas, thousands of registrations for Tony Romo. You think people will say, all right, here's what I'm going to do. Here's how I'm going to steal the election. I'm going to register as Tony Romo in every precinct. I'm going to walk in, I'm Tony Romo. Let me vote. Right? So I'm looking. So there's a guy at the Heritage Foundation named Hans von Spakovsky, and he writes a story about impersonation fraud. He says, one doesn't have to look far to find instances of fraudulent ballots cast in actual elections by, quote, voters who were figments of active imagination. In 1984, a district attorney in Brooklyn, New York, a Democrat, released the findings of a grand jury report that reported extensive registration and impersonation fraud between 1968 and 1982. Now, let's put aside the fact that 1984 is not that recent. All right, it says don't have to look far. Huh? All right, 84. All right, but I'm intrigued. All right, extensive impersonation fraud. Let's see it. So I write to von Spakovsky. Von Spakovsky and I have been kind of tangling over the years, but he still would email me things that he wanted me to put up on the election law blog. So I write to him. I said, can I see the report? Nobody has the report. I checked with all these people who write in this area. No one's seen the report except him. No response. So I write to him again. No response. So I write to the head of the Heritage Foundation. I say, look, a principle of scholarship is you have to make your data available so people can replicate it or falsify it. No response. So I go to the press. And Talking Points Memo, this liberal blog, does this whole story about this. And I was all set to go on the Rachel Maddow show. It was going to be my moments in the sun. And then the librarian at UC Irvine found someone in the Brooklyn DA's office, pretty amazing, who found the report, who faxed it to us. Within an hour, we had it up on the election law blog. What did it show? Impersonation fraud? No. A lot of fraud committed by election officials. My favorite story involved party officials. So there was an insurgent candidate running against the Brooklyn Democratic machine in the 1970s. And they were worried this guy was going to win. So party officials went into the Brooklyn Board of Elections. They went into the men's room and they hid above the ceiling panels in the bathroom. When the lights went out for the day, they climbed down, they went and they changed voter registration cards of people they thought would vote for the reformist candidate in the hopes that if it was a close election, they could use those cards to challenge the election. So that happened, but not impersonation fraud. Well, it's not a surprise. It's a dumb way to steal an election. So Jane Mayer of The New Yorker, an investigative reporter, interviewed von Spakovsky. First she says to him, not the first thing, but one of the things she says to him is, why didn't you give Hasen the report? And he said, what am I, Hasen's research assistant? Then she says, can you name any credible academics who believe that impersonation fraud is a big problem? He says, sure, I can name two. Larry Sabato, who you may have heard of at the University of Virginia, and Bob Pastor. Robert Pastor, who was at American University. Very eminent guy, was the vice president of American University. So she goes and talks to both of them, and they both say, no, it's not a big problem. Doesn't happen very much. So still waiting, right? So impersonation fraud, how big a problem is it? The Bush Justice Department spent 5 years looking for cases like this. They found about 100 and something cases of election-related crimes, most involving election officials, some involving absentee ballots, as I'll talk about in a second. How many involving impersonation fraud? 0. Texas, 2-year investigation. How many involving impersonation fraud? 0. There was a great study done by a journalist graduate school just before the 2012 election. They went to every attorney general's office in the country and said, tell us about all the election crimes in your jurisdiction since 2000. And they added them up, prosecutions. So you can look up way up here. Absentee ballot fraud, 23.7% of the cases, 491 cases. All right, go down registration fraud, ineligible vote, double voting, petition fraud, vote buying. All right, you got to go all the way down. Voter impersonation fraud, 0.5%. 10 prosecutions, 7 convictions. I'm not saying no voter fraud. I'm saying no voter fraud that a voter ID law is going to do anything about. So you want to steal an election. Here's a recent example from where I live in Southern California. Small town of Cudahy. The ballots would come in for the city election. City officials, behind closed doors, would steam open the envelopes. If they were votes for incumbents, they'd reseal them. If they were votes for the challengers, they threw them away. That's a way to steal an election. Right? The people who count the votes, that's a good way to steal an election. The other way to do it is with absentee ballots. All right, so all of you apply for absentee ballots. I'll give you $20. You don't even have to fill it out. Just give it to me. That happens every year. Not every year in North Carolina, but every year there are cases. There are convictions. What does your North Carolina law do about absentee balloting? It makes it easier. It makes it easier. So if the concern is fraud, they're not going about it in a very smart way. So what's this about? So let me suggest that a lot of this talk about voter fraud is about getting the Republican base excited. They're canceling your vote. They're stealing the election. Go out and vote. So there was a U.S. attorney scandal. A number of U.S. attorneys were fired, including one in New Mexico, a lifelong, reliable Republican U.S. attorney who was fired. And it turns out that he was being pressured by a Republican activist in New Mexico to indict a woman for voter fraud before the election. He said, quote, "You're not going to find a better wedge issue." So a lot of this is about politics. A lot of it is also about an attempt to suppress the vote, but I'm going to suggest not a very successful one, at least so far. Well, what about Acorn? What about Tony Romo and Jive F. Turkey Jr. and Mary Poppins? Well, Acorn, if you remember that group, which doesn't exist anymore, although they're still vilified all the time. They haven't been in existence for 4 years. Acorn had a broken business model. Here's what Acorn said. We've got to register lots of voters, lots of new voters. So here's what we're going to do. We're going to find very poor people who are desperate for jobs. And we're going to send them out with voter registration cards. So we're going to say, go register as many people as you can. And if you don't register enough people, you're going to lose your job. So of course, Mickey Mouse, born 1922, of course Mickey Mouse is registering to vote hundreds of times. But that doesn't mean that Mickey Mouse is showing up to vote on Election Day. And there's a kind of bait and switch. Lots of voter registration fraud. And Acorn had to turn the cards over. You can't just say, well, I don't think this one's real, so I'll just throw it in the garbage. That itself is a crime. And we have had that happen with other groups. But it didn't translate into, we haven't found a single Acorn fraudulent registration card that's led to a fraudulently cast vote. All right. So that's on one side of the ledger. Now let's turn to the other side of the ledger. This is where the people who are angry with what I just said feel a little better, and the people who are happy about what I said get angry with me. Indiana was one of the first states to pass a tough new voter ID law. Went to the Supreme Court. The Supreme Court said the law was fine. Then there was a great story that the AP ran after the first election. It was a story about a group of nuns in their 80s and 90s who went to vote. They went across the street to vote. One of their fellow sisters was the poll worker. She knew them for decades. But she couldn't accept their ballots because they were without driver's licenses. They didn't leave the convent very much. They didn't drive. Sorry, can't vote. Disenfranchised nuns. Great story, right? Now, of course, nuns would never commit voter fraud, except in 2012, we just had a nun who committed voter fraud, voted for her dead sister by absentee ballot, and so nuns commit fraud, okay. But not all nuns. This was a great story. The problem with the story, what was left out of the AP story was if you were over 65 years old in North Carolina, you could vote by absentee ballot without any ID. So were they disenfranchised? No. It was less convenient. Maybe they liked going to the polling place, but they weren't literally disenfranchised. Okay. But it's a good story. How many people are disenfranchised? We don't know. So here's the best numbers that we have. In 2008, about 3 million people cast votes in Indiana. About 1,000 people showed up without ID and cast a provisional ballot. About 137 of them ultimately got their votes counted. So that tells us something. It doesn't tell us a lot. Most of the people who show up at the polls without their ID just forgot their ID. We don't know how many people don't have ID. And in Indiana, if you're so poor that you don't have an ID, you can go to the polls, cast a provisional ballot, and then you have to travel at your own expense to the county seat and file a declaration of indigency. So people are not going to do that. But we have a hard time finding people who want to vote, don't have an ID, can't get the ID with some effort, and are literally disenfranchised. So social scientists have looked at this, who've looked at this, think the effects of voter ID laws so far, things may be changing, are much less than what we thought. There were some statements of millions of voters being disenfranchised. No evidence that that's true. The left, though, likes to talk about voter suppression. So here's a report that the Brennan Center issued before the election. Study, new voting restrictions may affect more than 5 million. May affect, okay, it's measured. May affect, and of those 5 million, 2 million included voters in Ohio and Florida who had the chance, they wouldn't have as many days of early voting, just like your change here. They still could vote early, just not on as many days. So a lot of those 2 million voters were going to still vote early, or they were going to vote absentee, or they were going to vote on election day. But look at what the left does with the Brennan Center report. Huffington Post, Brennan Center, millions of voters impacted by new photo ID, citizenship, and registration laws. Daily Kos, 5 million voters have been targeted by the GOP School of Election Engineering. Or Rolling Stone, GOP war on voting, new laws could block 5 million. 5 million people have now been disenfranchised just going over 3 websites. Democrats use claims of voter suppression to get out the vote and to fundraise too. So here's Donna Brazile fundraising. You know what they did to us in Florida? They're doing it to us now in Pennsylvania, Ohio, Wisconsin, and Texas. Now, Indiana passes this voter ID law. The Supreme Court gives it its blessing. And by the way, I don't know if you heard this, the judge who wrote the lower court opinion, Judge Richard Posner, a very eminent jurist who upheld the law, gave an interview last week and he wrote in his book, oops, made a mistake. Didn't realize there was so much voter suppression out there. Sorry. Oh, he didn't say sorry. He blamed the lawyers. Yeah. But what's happened is after the Crawford case and the Supreme Court's blessing of voter ID, what ended up happening is the laws started getting stricter. So Texas and North Carolina passed tougher laws. We don't know how much tougher these laws are and if they're going to affect turnout. Everyone's going to be watching, but nobody knows. The other thing we don't know is whether or not there's going to be a backlash, right? So no question what the law does is it puts up hurdles in front of voters. We don't know how many voters are going to be able to go over those hurdles, are going to bother to go over those hurdles. That's the unanswered question. Each time a new voter ID law and set of laws gets proposed today, the hurdles are higher. All right, so that's the story of North Carolina and situating North Carolina in the context of party. I now want to turn to situating it in the context of race. So, as you probably know, in 1965, Congress passed the Voting Rights Act. It had a number of provisions, but among the most important of the early provisions was a provision requiring that states and localities with a history of racial discrimination in voting had to get approval or pre-clearance before they made any changes to their voting rules. And under this standard, the covered jurisdiction had to prove, it was the burden on the covered jurisdiction to prove that the law would not make minority voters worse off. No discriminatory purpose and no discriminatory effect. North Carolina, 40 of your counties were covered under this provision until this summer. It was the Voting Rights Act was a very successful law. Department of Justice objected to 2,000 objections and to 2,000 voting changes over the course of 1969 to 1989. And more importantly, the law gave minority voting representatives of minority voting communities a seat at the table, a bargaining chip, the ability to say, you know what, can you tweak this law a little bit so it does not have a negative effect on our voters. And the Voting Rights Act has been tremendously successful. In 1975, there were fewer than 100 African-American elected officials from the 7 originally covered states. There were 3,200 of them by 1989. Hispanic office holders go from 1,280 to 3,592 in the 6 states with the largest Hispanic populations. Voting Rights Act was very successful. But the Supreme Court, in a case called Shelby County versus Holder this past summer, struck down the coverage formula of Section 5. And what this means is that all of the jurisdictions that had been covered by Section 5 of the Voting Rights Act, that they're all now relieved of this. Congress can come back and try and propose a new formula, but it's very unlikely, one, that Congress is going to do so, and second, that if the Congress did so, that the Supreme Court would think that the formula is acceptable. So the upshot is all of these jurisdictions, mostly but not only in the South, that had to go through this preclearance regime no longer have to do it. Now, your neighbor to the south, South Carolina, a couple of years ago, passed a new voter ID law, not quite as strict as Texas's. Department of Justice objected. Case went to trial. In the course of the trial, South Carolina made its law easier. Made it easier to prove your identity, made it easier to get around if you didn't have the right ID. And by the end of the case, the court said, South Carolina has made improvements, this law can go into effect. It was a kind of bargaining. In Texas, the courts blocked Texas law. What the court said there was, Texas has the burden of proving this will not make minority voters worse off. Here's what we know about IDs in Texas. If you're poor, you're more likely to lack ID. Members of protected minority groups, blacks and Latinos, they're disproportionately part of the poor population of Texas. Therefore, this law is blocked. After the Supreme Court decided Shelby County, that opinion was vacated, and Texas has put its law into effect. And so now there's new lawsuits. And I want to talk about those because they're pending right now in North Carolina. In both Texas and North Carolina, the Department of Justice is making two claims against the states. The first claim they're making is that the state's new harsh voting rules violate Section 2 of the Voting Rights Act. That's a different provision of the Voting Rights Act that applies nationwide. It's a very hard standard to meet. In fact, there's never been a case anywhere in the country where a voter ID law or a similar law has been blocked under Section 2. If the claim is going to have to make it under Section 2 as we currently understand it, it's going to fail. The burden is on the government, not on the state. The standard is different. It's a tougher standard, and it's going to be very tough to prove. The other thing that the Department of Justice is trying to do, and this is why the race or party question is so important, the other thing that the Department of Justice is trying to do is to get Texas and North Carolina recovered under the preclearance provision of the Voting Rights Act. Section 3 of the Voting Rights Act says, you jurisdictions anywhere in the country, if you engage in intentional racial discrimination in voting, a court has the discretion to subject you to preclearance, again, for up to 10 years. So the Department of Justice is asking Texas and North Carolina, because of their new voting rules, to be subject to this new restriction. Now, it's an easier case for the Department of Justice in Texas than it is in North Carolina. That's because just 2 years ago, a court in Washington, D.C. found that when Texas was doing its latest round of redistricting, it was doing so with racially discriminatory intent. Texas drew black legislators' districts, the court said, worse. Black Democrat legislative districts worse than white Democratic legislative districts, cutting the economic guts out of those districts, making it hard to run for election, hard to show success in your district. Texas's response to this is kind of funny in their brief. They say, oh, we were even worse to the white Democrats. Look at what we did to Martin Frost. Look at what we did to Wendy Davis. You may have heard of Wendy Davis, who's now running for governor. We made those districts impossible for them. Kind of an interesting defense. In North Carolina, there's not going to be, so far as we know, any direct evidence of racial discrimination as motivating this new law. And so the question is going to be, can you infer racially discriminatory intent from having passed this law, from effect? And it's not clear what's going to happen there. It's also not clear if a court believes that we can infer that this was a racially motivated law, that the Supreme Court's going to agree. The Supreme Court's very conservative. It's the one that just struck down part of the Voting Rights Act. They may not go along. So it's going to be a very tough road if what we're trying to do is to recover North Carolina under the preclearance provision of the Voting Rights Act. So here's why it matters if it's about race or party. If we can make the case that it's about race, then it's a Voting Rights Act violation. There's a judicial remedy. But not if it's about party. So I don't know if you remember this. This always gets laughs, only in North Carolina. This was the famous 12th Congressional District. Now, people outside of North Carolina, they can see that it's a funny shape, but here you can see that an area joining Durham and Charlotte, going along the I-85. You know what they said about this district? It was so narrow that if you opened your car door on both sides, you'd kill most of the people in the district as you drive down the highway. Why was this district drawn? This district was drawn because the Justice Department said, you've got to create another black district in order to comply with the Voting Rights Act. And the Democrats who controlled the legislature said, all right, we're going to draw this district, sure, but we're going to do so in a way that maximizes Democratic votes. And the way to do that is to carve it up into funny little pieces. So this was challenged. The first challenge to this district, to this districting plan, was brought by Art Pope. You've heard of Art Pope? Art Pope brought this challenge, and he said, this district is a partisan gerrymander. This is Democrats' attempt to screw over Republicans. And you know what? He was right. But you know what the court said? The court said, we don't know when taking party into account in redistricting is too much, so we're not going to police this. Go to town. You know, draw the worst drawn partisan districts you can. So a new set of plaintiffs brought a new suit. They said, did we say partisan gerrymandering? We meant racial gerrymandering. And this went to the Supreme Court. Your state had 4 cases on redistricting in the Supreme Court in the 1990s. You know, that's a pretty significant percentage of the number of cases the Supreme Court hears total. Right? The Supreme Court doesn't hear a lot of cases. 4 times it went up. And the Supreme Court said that what was wrong with this district was that the jurisdictions were taking, that North Carolina was taking race too much into account in how it drew its districts. And this was unconstitutional and unjustified. You didn't need to do this to comply with the Voting Rights Act. You did it because you were trying to separate voters on the basis of race. It was a very controversial theory, but it again illustrates the point that if you can make the claim that the problem is one about race, you have a much better chance of getting the courts to approve what you're doing than if it's about party. I want to step back now and ask the question, is it right for the courts to draw a distinction between race or party? And so here's Republican consultant Lee Atwater speaking in 1981, and you can hear this recording, which was just found and just released in this last year, explaining how the Republican Party can appeal to racist voters in the South. You start in 1954 by saying N, N, N. By 1964, you can't say N, that hurts you, backfires. So you say stuff like forced busing, states' rights, and all that stuff, and you're getting abstract. Now you're talking about cutting taxes, and all these things you're talking about are totally economic things, and a byproduct of them is blacks get hurt worse than whites. We want to cut this is much more abstract than even the busing thing, and a hell of a lot more abstract than N, N. When we talk about race and we talk about party, are they really so separate? So part of the reason that the Democratic Party appeals to minority voters is that the party supports policies which benefit minority voters. It's hard to think of discrimination against Democrats as merely incidental to minority voters, when upwards of 90% of African Americans vote for the Democratic Party. Given the significant overlap between the two groups, how can we separate race or party? Part of the reason African Americans and Latinos support the Democratic Party is because the platform of the party supports their interests. And part of the reason that the Republican Party is not attractive to members of minority groups is because the Republican Party opposes many of those redistributive policies of the Democrats. So race or party, the two, as they were in 1900, the two are intertwined. Now, I don't think the Republican Party is full of racists. It may have been more so in 1981. but there's still a racial element to the Republican Party. So just in the last few weeks, pollster Stanley Greenberg polled Tea Party, did focus groups with Tea Party members. And here's what he found. Base supporters of the Tea Party are very conscious of being white in a country with growing minorities. Their party is losing to a Democratic Party of big government, whose goal is to expand programs that mainly benefit minorities. Race remains very much alive in the politics of the Republican Party. So this idea that race and politics are separate, are bifurcated, is an artificial distinction, but with a real-world consequence. In the North Carolina redistricting case, if we call the plan a partisan gerrymander, there's no remedy. If we call it a racial gerrymander, there's a remedy. In the case of the new election law here in North Carolina, if we can say that it's motivated by race or has a big enough racial effect, then it's illegal. If we say it's about screwing over the other party, it's just fine. So let me suggest that this is not the best way to think about these questions. I think instead we need to question the assumption of Texas that it's okay outside the redistricting context to discriminate on the basis of party in the crafting of election laws. It's understandable why the court has been reluctant to take partisan gerrymandering on. We want jurisdictions to take party into account when they draw districts. We don't want you to stick Democrats and Republicans all together in a district where the representative doesn't know what to do because the district is so divided. But outside of the context of redistricting, why would it be legitimate to take party into account when you draw your election laws? And I would point you to, there was a Republican official who was interviewed on The Daily Show last night. I don't know if you heard about this yet, from North Carolina. In addition to making a number of racist comments, he also said, well, you know what this law is about? It's about hurting the Democrats. What's wrong with that? And so here's what I want to suggest is what's wrong with that. We can agree about what the standard should be for how we should run our elections, while we can't agree about partisan gerrymandering. So here's the standard we can agree upon, I think, I hope. We want an election system where all eligible voters, but only eligible voters, can easily cast a ballot which will be accurately counted. I don't think that's asking for too much. If that's the standard, then what we can say is that if a jurisdiction passes an election law and someone says it's going to hurt members of the other political party, let the state have to come forward with some real evidence of voter fraud, efficiency, some decent reason to balance against the potential for disenfranchisement. Now, voter ID gets all the attention, but let me suggest there are other things going on. So one of the things that's getting not a lot of attention, at least nationally, about your North Carolina law is if you go to vote and a poll worker makes an error and sends you to the wrong precinct, your vote does not count at all, and even if you're voting for president and you're eligible to vote for president. Even if it's a poll worker error. Well, you say, well, what kind of poll worker error? So here's a deposition from a case out of Ohio, where Ohio said, yes, perfectly fine to disenfranchise people who vote in the wrong precinct because of poll worker error. This is a deposition of a poll worker who was asked whether the number 798 in an address would be odd or even for purposes of sending the person to the right place, the right table, the right precinct. When asked whether the house number 798 was odd or even, the poll worker responded odd. And why do you think it's an odd address? Because it begins with an odd number. It starts with an odd number? Yes, 9 is an odd number. Note it doesn't start with 9, right? It starts with 7. 9 is an odd number. 8's even. So on election day, if someone came in with the address 798 and you had 2 ranges to choose from, you choose the odd for them? Yes. Okay, and so that's how you did it for all the ballots on election day? To determine if they were even? Yes. To determine if they were even or odd, you looked at the first digit of the address? No. I looked at the whole address. And if you chose, however many, if there were more odds than even numbers, it would be an odd address? Yes. Right? So we all know this, right? 798, odd, odd, even, 2 odds, 1 even. Right? We all learned that second grade math. Now, it's funny. I always get laughs when I tell the story, except this voter's now been disenfranchised. How can we have a rule that says it's okay to disenfranchise a voter who's gotten this person as their poll worker? So what I think we need to do is ask when an election law is imposing a burden on voters, right? So the election law is putting hurdles. Okay, you got to get this form of ID. We're not accepting the student ID anymore. And so you're not driving a student, but you're going to have to find some way on your own to get the DMV. And you can do it. And you can go when you go home to your parents' house, get your birth certificate. Don't make sure it's the certified one. You come back. People can do it. But the question is why? Why are we making them go over these hurdles? And my argument would be that if a state's imposing some burdens on the right to vote, it needs to have a good reason. The reason has to be a real one supported by real evidence. The law is solving a real problem, and that the way of solving the problem is closely connected to the ends. I don't like voter fraud. You want to stop voter fraud? Here's what if you said to me, what's the one thing you'd suggest? You've been studying this for a long time. What's the one thing you'd suggest to minimize voter fraud? I'd say, get rid of all your absentee ballots. That'd be my number one thing. It's not on the agenda. So, the cutbacks in early voting for efficiency. But we're keeping the same number of hours, so it's no problem. So now you're going to pay people overtime. They're going to work the same number of hours, but now they're going to have to work a 12-hour day, so you're going to pay them overtime. And this is going to cause a bottleneck at the polling place because now there are fewer days that people can go vote. And we're cutting off the weekend voting, people who work during the week. You can't come after 1 o'clock. Yeah. All right, what's the point of that? Efficiency? Why stop pre-registering 16 and 17-year-olds to vote? Too expensive? It's actually much more expensive later on to try and process their information. Better to get them when they're in the high school. It's really hard to come up with reasonable, non-discriminatory reasons why these laws were passed. So let me just conclude by saying that there's another reason why this shift from race to party makes sense. It's because of our current Supreme Court. The current Supreme Court is very hostile to racially based remedies for anything, in education, in voting, in anything. The idea that we're going to get the Supreme Court to reinvigorate the Voting Rights Act and to use it to go after Texas and North Carolina, I think is very unlikely. And I think that the Department of Justice filed these lawsuits as much for politics as they did for legal reasons. But the court is more likely to be persuaded that on the basis of party, that's where to draw the line. And the fact that Judge Posner, who's a Republican, who's a conservative judge, said, you know what, I didn't realize what was going on out here. There's a lot more intent to suppress. Even if that intent to suppress is not leading to a lot right now, to a lot of votes not being cast to actual disenfranchisement, we're moving and making it tougher and tougher. To what end? And so that's the claim I would make to the party. And it would apply, we wouldn't have to single out the states, say, you're racist, you're not racist. We don't have to do that if we do this based on party. It would apply nationwide. And we'd still be protecting minority voters, and we'd be protecting students. And we'd be protecting everybody. I suspect that in those states that are engaged in intentional racial discrimination in voting, they're going to have the hardest time making the case that their rules are governed by principles of sound election administration. So back in 1900, North Carolina resolved its election administration disputes with violence, intimidation, and ballot box stuffing. We're mercifully no longer at that stage. And in fact, there's no way that we could say that that House Bill 589 is as bad as what we saw in 1900, although some people make some very exaggerated claims. But just because it's not as bad doesn't mean that it should be acceptable. When we speak about core American values, topic of this lecture, core American values, the key core American value I'm talking about here is the right of all eligible voters, but only eligible voters, to cast a vote that will be accurately counted. You know, we have a great democracy. It's not the democracy of Hosni Mubarak and Ayman Noor. It's not the democracy where we announce the election results beforehand. But so we should have voting rules that give the same respect to our democracy as we would want for any of us. Thank you very much.
All right, so I'm on, right? Yeah. So So we've got time for some questions, so raise your hand and I'll run around Oprah style with the microphone. But you're so young, you don't even remember Oprah running around Oprah style. But I would. Everybody wins or something, right?
Everybody wins a car.
Everybody wins a car. All right, so questions. Come on, give me hands or something, or in the back. I know you.
Do you think if this was an attack to disenfranchise Republican voters, that it would be such a big issue because of the tendency for minority voters to be Democrats?
Well, so this is an interesting question. Democrats have been able to take the high road on this. And they like to claim that the reason they're taking the high road is to save value to vote for. I don't believe it. I believe that Democrats take the high road because expanding the electorate helps Democrats. So a big part of the problem here are not people who are literally disenfranchised. It's that the Democratic Party, especially in presidential election years, where it's trying to get turnout up, focuses not just on old voters, experienced voters, but voters who've moved, who've never registered before. Those voters, you put a little stumbling block in front of them, they're not going to bother to vote. So you know what Democrats love? They love same-day voter registration. So all you have to do 20 days before the election, you show up, you register to vote, and you get to vote at the same time. So I only got to get you to the polls once. So California, my state, recently passed same-day voter registration. It's going to go into effect in 2014. Right? We love the right to vote, so they can take the high road. But the fact is, this helps Democrats. I think it would be the same, except the politics of the situation now, unlike 1900, is that Democrats want to expand the electorate as much as possible. Republicans don't want to expand it, or at least not expand in a way that's going to be at their expense. But I don't think that Democrats are acting out of public interest. I think they're acting out of self-interest as well.
So I would just say that I actually voted absentee as a way to vote back home. I haven't just gotten back home, so having to drive back. But how do you think North Carolina's laws actually compare to Virginia's laws? I know Virginia does not have any early voting and has new voter ID laws as well. How do you think about that?
Well, Virginia's ID laws are not nearly as strict as North Carolina's. So that's that comparison. North Carolina is among the strictest. Virginia is not. In fact, Virginia got approval for its voter ID law when it was still, we still had Section 5 of the Voting Rights Act applying to parts of Virginia. But the early voting question is a great question. So one of the arguments against, let me back up. DOJ, the Department of Justice, has not attacked every part of the North Carolina law. They've only attacked parts of it. One of them is early voting. And the response on early voting, which it sounds pretty persuasive, is, look, North Carolina doesn't have to have early voting. There are lots of states, Virginia's example, it doesn't. Pennsylvania doesn't have. Where's the constitutional right here? We don't have to give any early voting, so the fact that we're giving 10 days instead of 15 days or whatever it is, what's the problem? And I think there's something to that argument. But we saw something interesting in Ohio in 2012. Ohio cut back on early voting. They cut back, got rid of the last weekend. Now, the last weekend was significant, again, race and party. The last weekend was significant because black churches in Ohio would have this so-called Souls to the Polls Day, where they would, right after church, they would drive people to go vote. And it was eliminated. Now, when the Republican legislature in North Carolina got rid of the last weekend of early voting, they were incompetent. They got rid of it for everybody except for military voters. So the Democrats came in and they sued and they said, you can't just let military voters vote and nobody else. Now, I think as a matter of precedent, Democrats were wrong when they made that claim because military voters face different burdens than everybody else, and giving them a little more slack, to me, makes a lot of sense. But be that as it may, the case goes up to the Sixth Circuit Court of Appeals, and the judges say, you've got to restore your early voting. Two of the judges say the reason you do is because you can't treat military voters better than everybody else. Which, of course, the way to deal with that, you could also take away the military voters' rights. But Democrats didn't want that remedy because that would not look very good. But one of the judges, Judge White, who concurred, she said, you know, I don't think this is a big burden. In Ohio, 33 days of early voting. You could vote by absentee. You could vote on election day. She said, here's the problem. I live in Ohio, and I saw what happened. In 2004, there were terrible lines, especially in parts of Cleveland and other cities in Ohio. And in 2008, the legislature expanded early voting, and it got rid of the lines. And things moved better. Even though we had more turnout, there were no long lines. I don't trust you, Ohio. If you're going to cut back, I don't think you can handle the election. Now, that's a theory that came out of nowhere. It's like this idea that once you give a right that you don't have to give, you can't take it back. I'm still unsure about that idea, whether we want to extend this principle to across the country. But there's something to this idea. If we don't do it in a lot of states, then what's the problem? So I think it's a good point.
So you mentioned around election time you usually get a lot of calls asking things are really different, what policies are going to encounter. I guess is the fact that nothing's ever addressed until a couple days before election day, is that just an American thing? Does it happen in other democratic countries? And if it is just an American thing, do you think it's ever going to change?
Most democratic countries don't run our elections like we do. So, for example, election for president is conducted in more than 8,000 election jurisdictions with their own rules. I start my book, The Voting Wars, by telling the story of a very close election for a state Supreme Court justice in Wisconsin, where the election was very close. At the end of the night, the Democrat is ahead by 200 votes. Very close, and John Fund, conservative commentators, talking about voter fraud rampant in Dane County, in Madison. The next morning, there's a press conference by the Waukesha County clerk, a woman named Kathy Nicholas, and she says, I was storing the votes on my laptop that were coming in from different parts of the county, and I forgot to include an entire city. When you add those 15,000 votes in, it's not the Democrat ahead by 200, it's the Republican ahead by 5,000. And then there's this woman, Ramona Kitzinger, who was looking over her shoulder, literally looking over her shoulder at the press conference, and she's the Democrat who's supposed to be watching to make sure that this Republican was doing things right. The next day, Kitzinger issues a statement which says, I'm 80 years old. I don't know anything about computers. I think the numbers Kathy was showing were right, but I'm not sure. I'm very, very confused. That's literally what she said. The biggest problem we have with our elections is not partisanship, it's incompetence. There's something called Hanlon's razor, which is a computer science principle, which says, don't attribute to malice that which can be explained by incompetence. And I think the way we run our elections is a national embarrassment. So at the end of my book, I propose all these things we can do. I, for example, believe we should have national voter ID and universal voter registration. We should have the federal government go out and, as soon as people are in high school, before they leave high school, if they're graduating or dropping out, help them get all the documentation they need at no expense, register them, give them a number, a voter ID number that goes with them their whole lives. And on their voter ID card, which will be electronic too, let them use their thumbprint, because you may forget your ID at home, you're not going to forget your thumb. Universal voter registration, national voter ID. This is a proposal that has united Democrats and Republicans. They hate it. Democrats don't want anything to do with voter ID. Republicans don't want universal voter registration. So I propose all kinds of things, but we're in such a partisan moment right now. Let me tell you how bad it is. After 2000, Congress passed the Help America Vote Act, which provided money for voting machines, and it set up a group called the United States Election Assistance Commission. Has anyone ever heard of them? One person who's a professor of political science has heard of them. The United States Election Assistance Commission. It has basically two jobs. One, it certifies voting machines as being reliable. Two, it provides advice on best practices. The day that it was formed, the National Association of Secretaries of State, which is the top group for the the statewide election officials came out and said this group is too powerful. Republicans have blocked appointments to this group. The U.S. Election Systems Commission, if you go to their website and you look at the page for commissioners, 4 vacant seats. We went through the 2012 election with no commissioners on the United States Election Systems Commission to provide advice about best practices or to certify voting machines. We can't even have an advisory board. So I'm very pessimistic in the near term that we're going to get any kind of national reform. How are we doing on time?
Time for 2 more, I guess, maybe?
Okay.
1, 2. All right.
So I'm very interested in hearing your thoughts about running for elections, super PACs, Citizens United, and the
So that's a slight shift of gears. The question was about what's happening with campaign financing and what's likely to happen with super PACs, Citizens United, the Supreme Court. That's a really long discussion. That could be an hour. I won't subject you to that. Let me just say that the question at the Supreme Court is how campaign finance reformers are going to lose. Not if, but how. So if they lose narrowly in this case that the Supreme Court just heard, the result is going to be that you'll be able to give a $3.5 million check to a member of Congress who can then divvy it up to other people. That's the good result. The bad result is all of our campaign finance contribution limits are going to be called into question. So in the near term, I'm very pessimistic about the constitutionality of campaign finance reform. What will change that? If a couple of conservative justices retire from the Supreme Court and you get some new appointments, what's the easiest way to change the Constitution? Right? You could amend the Constitution, you could have an Article 5 constitutional convention, or a Supreme Court justice could have something different for breakfast. That's the easiest way.
I'm going to preface my question. It seems like recently the Republican Party has sort of demonized the president and other Democratic political leaders because they took their education and all their supported by minorities. And so I guess I'm wondering, I think that this, behavior kind of keep people from voting would actually be counterproductive in terms of minorities actually realizing what is all about. So do you think that the strategy actually backfire in instead of trying to use sort of semblance for racial tolerance? Do you think maybe more focused on that?
Yes, well, certainly as a PR matter, passing laws that are perceived by members of minority groups as making it harder to vote is not a good PR strategy. But in terms of the backlash, in my book, I start off one of the chapters with a story about ads that were run by Latinos for Reform. They were run against Harry Reid in Nevada. When he was up, remember he was up against Sharon Engel? Am I saying her name right?
Yeah.
Yes. So these ads ran in Spanish on Univision in Nevada that basically said, don't vote. It said, Democrats have done nothing for you on immigration reform. They teach them a lesson. Stay home. So who are Latinos for Reform? So the guy who's the head of Latinos for Reform is a guy named Robert de Posada, who was a former RNC person. And I looked into the funding of Latinos for Reform. The largest funder of Latinos for Reform was a guy named John Finn. Doesn't sound Latino. I couldn't find anything in his bio about him being Latino. He lived in Hermosa Beach, and he was a big anti-abortion guy. That was his big thing. So kind of sounds like this was looking like AstroTurf, looking like a Republican organization, looking like a Latino organization, but really Republicans trying to suppress the vote. Well, Democrats had a field day with this. So Democrats kept showing the ad over and over again. They loved the ad. And so it was a way to mobilize people. And so it's true that some of these laws unnecessarily put hurdles in front of people. Hurdles that most people can overcome, but they're still hurdles. And we shouldn't have them there without a good reason. But the question is whether people not only overcome the hurdles, but go even further. And I think it's at least possible that in North Carolina and elsewhere, people are going to respond to attempts to make it harder to vote by using that as an organizing principle and actually voting in larger numbers. And we're going to see. I think the fight in North Carolina, especially given the current state of the law, is much more likely, for those who oppose the current law, much more likely to be won politically than in the courts. And so I know you guys have protests, and there are all kinds of, there's all kinds of I don't want to say social unrest, but lots of people expressing their political views here, and I think that's the way this is ultimately going to get decided in North Carolina.
Well, that sounds like a great closing note, so I want to thank Professor Hasen so much for this great talk tonight. So again, just want to give another round of applause.
From October 24th, 2013, this has been VoterRadio.com's coverage of a presentation from Richard Hasen entitled North Carolina's New Front in the Voting Wars. Hasen is a senior editor of the New Republic and professor of law and political science at the University of California, Irvine. The event was hosted by the School of Public and International Affairs at North Carolina State University in Raleigh.